his motion to recuse all of him. Let him go first. I got that. Oh, are we ready to start the meeting? Okay. Everybody ready?
Mr. Mina on?
Yeah, can I make sure I can hear you?
Okay. I'm gonna go ahead and gavel in. Good afternoon, everybody. I would like to call this special Southern Shores Planning Board meeting of March 19th, 2025, 3 o'clock in the afternoon to order, please. If you will, please stand with me and say the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Mina, can you hear us?
I can hear you.
Okay.
Mr. Chair, if I may, more
Can you hear me?
for the town staff here today, I just wanted to note for the record.
Are you able to hear me?
We can hear you. Stand by.
And I just wanted to note for the record that Mr. Mina is appearing by Zoom today, and this is due to town council's prior ban of his presence on town property. So he is on by Zoom, and I believe you were confirming that he could hear, and as he's participating remotely today.
Okay, thank you.
Mr. Mina, can you hear us? Let's try this one more time, please.
I can hear you.
Excellent.
I-
Can you turn
I
the
can hear you.
volume up for us, please? Stand by. We just want to make you a little louder here. Mr. Mina, can you see us?
Yes, I can.
All right, thank you.
Continue on. Okay. Next item on our agenda is approval of today's agenda. Could I get a motion to approve the agenda as written?
I'll make a motion to approve the agenda as written.
Thank you, Tony. Could I get a second?
I'll second.
Thank you, Charlie. Any discussion? Vote?
Aye.
Okay. At this time, in the course of our agenda, we have public comment, and I believe Mr. Mina has asked to be signed up ahead of new business, and he would like to read a statement at his public comment time. So, Mr. Mina, I'm going to allow you to make that statement at public comment, and you have 3 minutes. Thank you. See you.
Mr. Mina, if you can hear us, the time is now for you to make some public comment. I think you had a notice that you wanted to read before the board. There you go. And now you're unmuted, so we may be able to hear you.
Yes, I have a notice of West Haskett's premeditated embezzlement scheme witness tampering, disorderly conduct, and insurance fraud scheduled for March 19th, 2025. Applicant Anthony S. Mina files this document to notify the planning board, Board of Adjustments, that West Haskett does not even have a legal right to use the town's money to turn on the lights at Town Hall on March 19th, 2025 for the appeal of the subdivision denial. Not to mention the thousands of dollars of costs that will be imposed on taxpayers because of West Haskett's fraud. Town Code 36-414B requires property affected by zoning amendments, rezoning them from subdividable to unsubdividable to have posted notice prior to the hearing on the zoning amendment. Public records requested submitted with the lot subdivision application and variance application approved 75 East Dogwood Trail was not notified as an affected property from the March 31st, 2023 lot West amendment. As such, West Haskett must approve the lot subdivision or suffer more legal consequences. West Haskett's argument through his paid attorney, which is paid with money embezzled from Southern Shores taxpayers, at 326 of the variance YouTube video, that we are not here to discuss the validity of the notification of lot with amendment, is as pathetic as the drunk 16-year-olds caught inside the bar with claims she already tricked the bouncer into letting her in the bar with her 21-year-old sister's ID and should be allowed to continue drinking with her fake ID. Lauren Womble and Jay Wells got caught misrepresenting Town Code 36-414B at the variance hearing, and times are listed in the notice filed. And after getting caught misrepresenting Town Code, wanted to argue the validity of the ordinance, which requires posted notice at affected property, is not arguable. Southern Shores property owners work hard for their money, for taxes, and what they are getting in return is the equivalent of watching West Haskett on surveillance walk into planning board meetings, smoking crack cocaine and passing the illegal drug around to as many people as they can. Except the illegal substance West Haskett is poisoning the planning board with is his lies and embezzlement scheme. Southern Shores property owners deserve a planning board complying with the town ethics policy, not conspiring with West Haskett's lies. Southern Shores has been notified that there's a pending fraud insurance claim against Southern Shores, specifically relating to West Haskett hiding the March 31st lot with amendment from applicant. Not having posted notice at 75 Dogwood Trail, but still claiming a lot with amendments affects 75 East Dogwood Trail. West Haskett is currently in contempt of the Dare County Superior Court, and there is a pending motion to sanction West Haskett with fines and jail time pending in Dare County Superior Court. A true and correct copy of the motion was provided to the planning board. West Haskett's refusal to provide a verified copy of the order of the record from the October 21st, 2021 variance hearing violates 8 U.S. Code 1815-12C1 and 2. Tampering
Mr.
with
Mina?
a victim, a witness.
Chairman Ward
victim,
here,
or
Mr.
informant.
Mina.
Yes.
I'm going to give you about another minute to wrap it up, and then we're going to move on. Your 3 minutes at public comment is up.
Whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes an official proceeding, or attempts to do so, shall be fined under this title and imprisoned not more than 20 years or both. Lastly, Town Code Section 22(1) states any person who shall do or engage in the following shall be guilty of disorderly conduct. Frequent any public place and obtain money from another by an illegal and fraudulent scheme, trick, artifice, vice, or attempt to do so. Southern Shores Town Planning Board, Board of Adjustments, Town Employee West Haskett, Southern Shores paid attorneys are all guilty of disorderly conduct at the October 21st, 2024 variance hearing, which cost applicant $350 for the fraudulent scheme to misrepresent Town Code 36-414B. Southern Shores Town Planning Board, Board of Adjustments, West Haskett, and attorneys will all be guilty of another count disorderly conduct the second they stepped foot in Town Hall, March 19th, 2025. West Haskett, Andy Ward, and the attorney's attempts to misrepresent Town Code 36-414B substantiate criminal conspiracy law violations, and any attempt to pretend they did not understand Town Code 36414B strictures which clearly state, in addition to 36-414A, posted notice is required, is not supported by law either. When interpreting ambiguous terms in a contract, courts must follow the contract pro partum rule, which means the ambiguity will be construed against the party who drafted the contract, essentially placing the burden of unclear language on the draft. Courts will also consider the plain meaning of the words, contacts, in the contract. Industry standards and prior dealings with parties to reach a reasonable interpretation. West Haskett has done nothing but fraud applicant Southern Shores property owners for almost 2 years since his March 31st, 2023 lot with amendment application was filed. An applicant will be seeking legal consequences against everyone involved with West Haskett's fraud in Dare County Superior Court and North Carolina Federal Court. Thank you.
Mr. Mina, we heard you loud and clear there, and we will enter this as part of the evidence package. Okay, anyone else wish to speak to public comment? Ma'am? If you'll come to the podium and state your name, you have 3 minutes.
I'm Sherry Lemnios, and I own a lot that's a few lots away from Anthony Mina. And I came here because I thought this was going to be about his desire to subdivide his lot, and I came here to speak against that. But I really couldn't understand a lot of what was just said, and I'm not sure if it really applies. So I don't know what to say, except that I'm against the subdivision of his lot.
Okay.
And the rest of the stuff is just, I don't understand.
Okay, well, thank you for your comments and,
Okay.
yeah. Okay. Old business, none. And now as we move into new business, the planning board will be performing the duties of the Southern Shores Board of Adjustment to consider APA 25-01, an appeal application submitted by Anthony S. Mina to appeal the zoning administrator's denial of Mr. Mina's January 6, 2025 request to subdivide the property located at 75 East Dogwood Trail. At this time, I will ask the board's attorney, Jay Wheelis, to give us instructions, direction, and opening comments concerning the order of the evidentiary hearing before us this afternoon.
Thank you, Mr. Chair, and good afternoon to the board and public. My name is Jay Wheelis. I represent this Board of Adjustments. As the board's attorney, I will assist the chair and/or vice chair in running the formal structure and flow of the hearing itself. Questions of evidence are decided by the chair and/or vice chair, sometimes with my assistance, sometimes not. A hearing before the Board of Adjustments presents an opportunity for an appellant to be heard after a review or determination of a zoning official, but before having to seek relief in a true North Carolina Court of Justice. The board will attempt to follow the formal rules of evidence. All evidence must be relevant, substantial, and competent. Relevant means material to show how some burden of proof on this appeal will be met. Substantial means something a reasonable mind would regard as sufficient to support a specific conclusion relevant to the appeal. And competent means trustworthy and reliable. The burdens of production, persuasion, and proof lie with the appellant, Mr. Mina. The quantum of proof is that all decisions must be based on competent, material, and substantial evidence in the record. This is not a legislative public hearing where the public is invited to give opinion or provide wise thoughts, comments, or guidance to the board about how to write an ordinance or what ordinance to approve or disapprove. To the board, I offer you these thoughts. An appeal from a decision of the town zoning administrator is similar to, but not the same as, a variance hearing. Like a variance hearing, you are the finders of fact. If we reach the ultimate appeal after all preliminary motions are heard and decided, your duty is to review the record, hear testimony, consider documents, and in the end, hear arguments from the parties and/or their attorneys. You are to make one of the following decisions. Affirm, in whole or in part, the denial of the subdivision plat. Reverse, in whole or part, the denial of the plat. Modify the denial of the plat. You have all the powers of the zoning official who made the decision to deny the subdivision approval. Each decision requires a 3/5 vote, not a 4/5 vote like in a variance. A simple majority carries the day. As in a variance, it is important that your decision be complete with a full account of the reasons, that is, the facts on which your decision is based. Your consideration of the appeal might necessarily mean that you need to interpret what certain language in the ordinance means. Accordingly, I give you this guidance. Your primary objective is to determine the intent of the town council in adopting the language at issue and to apply that interpretation to the subdivision plat or plats submitted by Mr. Mina. You should do the following things. 1, listen carefully to the arguments of the town and the appellant. 2, determine and give effect to the intent of the board of the town council. 3, examine the ordinance text itself. If clear and unambiguous, apply the text as written. 4, if the ordinance provides definitions, consider the definitions thoroughly. 5, if the ordinance provides other interpretive guidance, use it. 6, contrast other provisions to provide meaning to the term or section at issue. 7, apply a logical meaning to words. 8, use a dictionary if necessary. 9, avoid absurdity. 10, if ambiguity exists, resolve it in favor of the property owner and the free use of land. Mr. Chair, we will now determine whether any board member has bias or a conflict of interest. Before asking each of you certain questions, by full disclosure, last week I asked Chairman Ward to contact each board member by telephone and implore them to read every page of every motion filed by the appellant and the town. I cautioned the chair to limit the conversation to this one item and not to discuss any substantive matter about this hearing. I believe the total number of motions is 8. Please answer affirmatively or negatively, as the case may be. Does each member confirm that he or she has read each of the motions and supporting documentation?
Yes.
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 Now, turning my attention to the board, has any board member communicated with other board members other than the telephone call I mentioned that you may have received from the chair? Have you communicated with the parties or town staff about this appeal?
No.
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 If you did have a conversation with the chair in which he asked you to review every written motion, was this direction by him to read all the motions the only matter raised during that conversation?
Yes.
Yes.
Does any board member have a fixed opinion that is not susceptible to change?
No.
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 Does any board member have a close familial, business, or other association or relationship with any party?
No.
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 Does any board member have a financial interest in the outcome of this matter?
No.
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 Ms. Arizaga-Wamble, do you challenge any member of the board?
I do not.
Mr. Mina has filed a motion requesting the recusal of Mr. Andy Ward and a second similar motion requesting the accusal of Ms. Jan Collins and Mr. Robert McClendon. Mr. McClendon is not a board member for this purpose of this hearing. We'll proceed now with Mr. Mina's examination of Mr. Ward under oath. Mr. Mina, the board grants you up to 5 minutes to cross-examine Mr. Ward about the relevant facts which lead you to question his bias and/or his conflict of interest in this appeal. During this cross-examination, the vice chair, Mr. DiBernardo, will rule on questions of evidence, if any. And if you are unmuted, Mr. Mina, please proceed. We need to have Mr. Ward sworn, please. Yeah, for the oath.
Just Mr. Ward? Just raise your right hand.
You can do it from here.
You can do it from there. Do you swear or affirm that the evidence you shall give to this board in this action shall be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Mina, the board grants you up to 5 minutes to cross-examine Mr. Ward about the relevant facts which lead you to question his bias and/or conflict of interest in your appeal. Please proceed.
Yes, Mr. Ward, at the October 21st, 2024 variance hearing, you agreed to comply with the town's ethics policy. Isn't that correct?
Yes.
And when I'm sorry, what's she saying?
He said yes.
Yes.
I thought somebody else was speaking. I apologize. And when I objected to Ms. Womble and Mr. Willis misrepresenting Town Code 36414B, you stated that I am not helping my case and I'm accusing the whole town of impropriety. Can you please tell me how you're complying with the Code of Ethics when telling me I am not helping my case for objecting to attorneys demonstrating misconduct in the hearing? How is that the Code of Ethics, sir?
I don't have the Code of Ethics in front of me, so I can't really respond to your question. If you want to pare it down a little bit, I'll be glad to address it.
I apologize, sir. The Code of Ethics is Exhibit A of my motion for Andy Ward's recusal. And I believe you also said you were familiar with the Code of Ethics at the variance hearing. You please tell me how telling me I am not helping my case for objecting to attorney misconduct is in compliance with the Code of Ethics of Southern Shores?
Could you say that question again?
Could you please tell me how saying to me that I am not helping my case because I have objected to attorneys misrepresenting Town Code 36414B and saying I am accusing the whole town of impropriety is in compliance with the Code of Ethics? The way I interpreted what you were saying is you were acting like I was insulting the town because I am opposed to attorney misconduct during my proceedings, sir.
I
Can you
believe,
tell me how
I
you're
believe when
running
I
the
spoke,
hearing?
Mr. Mina, I believe when I spoke, you had accused numerous people of misconduct, and it was a reaction to that. And that's it. No Code of Ethics violation there at all.
Your answer's inappropriate. You lack the morale to be sitting on the hearing today. I also have another problem. I appealed the October 21st, 2024 variance hearing, served an order from Dare County Superior Court to Southern Shores, which ordered a complete copy of the record within 30 days, which the town is in contempt of. Can you please tell me how the planning board is, the entire planning board is not in complete contempt of Dare County Superior Court by not providing a complete copy of the record within 30 days of December 18th, 2024?
I'm not sure that's in the planning board's purview. That would be back to the zoning administrator.
Two minutes, Mr. Mina.
Yes, sir. Could you please tell me how you found no competent evidence presented in my motion to preclude the October 21st, 2024 variance hearing when I caught both attorneys fraudulently misrepresenting Town Code 36414B, which was the entire reason I had to file for the variance hearing? How could you please tell me how you signed an order saying there was no evidence of fraud when I caught the attorneys like 4 to 5 times on the record misrepresenting Town Code 36414B, and you also tried misrepresenting the same town code, saying it doesn't apply to regular amendments without map amendments? You misrepresented it yourself. So can you tell me how you think you're fit to sit on the board right now?
How am I fit to sit on this board right now?
Yes, when I have you on camera at the variance hearing, misrepresenting Town Code 36414B. Why do you think you're fit to sit on the board right now?
That would be for the town to understand, but I think I'm more than capable of sitting on this board. I've lived in this town for 40 plus years, and I know a lot of what is going on in the town by being on this board, and I plan on being on this board for a while longer.
I apologize, sir. I apologize, but I don't believe you're fit to be on the board. Living in the town and knowing things that go on in the town does not make you fit to be on the board. Being able to comply with town code.
That would be your opinion, and I believe.
You lack what is.
Mr. Mina, we're at 6 minutes now. We'll give you one more question, please, if any.
I have filed a complete motion for Andy Ward's recusal due to his false statements, which are on camera at the October 21st, 2024 hearing. I respectfully request that he step down and let other members hear the case because he refused to comply with the Code of Ethics last time I allowed him to be on the hearing.
All right. Well, we thank you for your argument on that matter. Ms. Arazaga-Wamble, I'm sorry, do you have any follow-up questions?
I just, in light of Mr. Mina's questions, I just wanted to ask a couple questions for the record, if I may. Chairman Ward, the decision from the October 21st, 2024 hearing Mr. Mina was referring to, that was memorialized in great detail in the formal order.
I can't hear what you're saying. I apologize for interrupting.
It's okay. We're going to pull the microphone closer to her. Thank you.
Chairman Ward, Mr. Mina referenced a variance proceeding that occurred on October 21st, 2024 in his questions to you. Do you recall this proceedings?
I do.
Okay. And the details regarding the board's decision, the basis for the board's decision, including yours, are set forth in great detail in that 9-page order that was entered and signed by yourself. Is that correct?
Correct.
And so regarding the basis for deciding about a ethics opinion or a motion to preclude, all those findings of facts, conclusions, or laws are set forth in that order. Is that correct?
Correct.
That's all I had.
Okay,
Now speaking is the vice chair acting as chairman.
at this time, I would like to entertain a motion to either recuse Mr. Ward or not recuse Mr. Ward. I'm entertaining a motion.
I make a motion not to recuse Mr. Ward.
Do I have a second?
Second.
Any discussion? All those in favor of the motion?
Aye.
Aye.
Thank you. And just to note, Mr. Ward abstained from that, which under the rules of procedure would mean that he's voting affirmatively.
So it's 4 to nothing.
All right. Thank you, Mr. Vice Chair. Mr. Ward will continue to remain on the board Next, Mr. Mina, the board grants you up to 5 minutes to cross-examine Ms. Collins about the relevant facts which lead you to question her bias and/or conflict of interest in your appeal. But first, we need to swear Ms. Collins, please.
Ms. Collins, please raise your right hand. Do you swear or affirm that the evidence you shall give to this board in this action shall be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Mina, please proceed.
Yes, I apologize, but I wanted to let you know that I cannot object to things because you're muting me. And I was trying to tell you that I couldn't understand what Ms. Womble was saying when she was asking Mr. Ward something or saying Mr. Ward something, but the meeting kept going on. And I couldn't understand anything Ms. Womble said.
All right, stand by. I don't think we did, nobody muted him, did we? Oh, okay. All right. Just for clarity's sake, do you remember the couple of questions that you asked? Let's back up. We'll leave Mr. Mina on as muted, and maybe that will help. And we did move the microphone up closer to Ms. Womble Arizaga Womble, excuse me. Good. Okay, thank you. All right, test.
Test. Is that
Okay.
better?
I can hear you much better this time.
Thank you.
Okay. Chairman Ward, for the record, do you recall the proceedings, the variance proceedings from October the 21st of 2024 that Mr. Mina was questioning you about?
I do.
Okay. And the board's findings of facts, conclusions of laws, and details supporting the board's decision of those proceedings were documented in a 9-page order that was signed by yourself. Is that correct?
Correct.
Okay. And I guess, is there anything about those proceedings that you feel disqualifies you from serving and sitting as a impartial decision maker on this board today?
No.
Thank you.
All right, based on this question, we did vote. Did you hear the motion that was made, Mr. Mina?
I apologize. Was that Tony Bernardo that made the motion not to ask for any
No,
Ward's
sir.
recusal?
No,
I'm sorry?
sir. Mr. Geis made the motion to not, excuse me. Mr. Reese made the motion to not recuse Mr. Ward. That motion was seconded by Ms. Collins, and it was a unanimous vote. So Mr. Ward will remain seated on this panel.
So everybody understands that Mr. Ward is on camera misrepresenting town code and they still want him on the board is what I, in comprehending you saying.
Well, I don't know what you comprehend I'm saying, but he will remain on this board as a member of the 5-person voting board. Based on your questions, his answers, and Ms. Womble's questions and answers to those. Mr. Mina, now that you can hear us okay, we're going to move on to Ms. Collins. We need to swear her, or did you swear?
I just
You did, okay, thank you. You've got 5 minutes with Ms. Collins, please, to tell us or to somehow show the relevant facts which lead you to believe that she either has bias and/or a conflict of interest in hearing this appeal. Please proceed.
Ms. Collins, I have a question for you and I also have the same question for the rest of the board members. Do you have a relationship with Linda Lalby?
Linda Lullaby?
Yes.
Lauby.
I don't know.
Lalby, I don't know. Lobby.
Can you pull that, please?
I'm sorry, Mr. Mina, I do not know her.
Do you understand that zoning code is written so there isn't a gray area for subdivisions? Meaning West Haskett can't have a bad day and decide want that lot cannot be subdivided, but have a good day and decide the same lot can be subdivided. It's just clear as black and white in zoning code. You understand that part of the zoning code?
No.
No?
By answering no, are you saying that's not your interpretation of the ordinance?
Right.
Thank
That's
you.
not my interpretation.
Can you please tell me where there's discretion for the zoning code officer?
So I guess I'm going to interject. I don't know, this is not relevant to any personal bias that, alleged personal bias that Ms. Collins would have. It appears that this is getting off into the weeds a little bit. I mean, at this juncture, we're only talking about the board members' fitness to serve in proceedings for this hearing. The town, I did not challenge any board members on behalf of the town staff in these proceedings. And so we're only here in regards to Mr. Mina's challenge as to their personal bias or financial interest or predetermined decisions. So I guess I would object and just say we're getting off of the points at this point.
I will
No,
sustain
see, I'm
your
right in the-
interjection there, Mr.
right.
Mina. We
Yes,
want you to
I have a
stay
direction to go.
very clear and focused on why you think Ms. Collins is biased.
Because Ms. Collins criticized me on October 21st, 2024 for not having my real estate contract contingent on a lot subdivision.
Is that a question?
I am forming a question, which means I want to know how many real estate contracts Ms. Collins wrote contingent on a town employee committing fraud during the course of the real estate transaction.
Mr. Mina, I spent 23 years in real estate. I wrote many contracts with many contingencies. When a customer or a client that I was working with had a desire, it was written in the contract. When we were talking and I mentioned to you that it was so important that you were going to subdivide this lot, why didn't you inform your real estate agent? And they would have written it in the contract that the contract was contingent on a subdivision. That is all. I was just being straightforward with knowledge. And I told you I'd been a nurse for 10 years and again, working with doctors, and everything had to be in writing. I was not ridiculing. I was just using fact. That's all.
May I ask you, how many real estate contracts did you write that were contingent on a town employee committing fraud? So if
Same question. She answered your question, Mr. Mina. I'll
you
give
didn't
you
answer
one
the
more
question,
question.
it requires a number, sir.
I would give you one more question to ask. Your 5 minutes is expired, and you need to keep it to bias on Ms. Collins' part.
You're not allowing her to answer the question. I asked for a number, sir. How many real estate contracts did she?
We
write
understood your question.
contingent on town fraud?
We understood your question. The question is out of order with regard to fraud and so forth. She has answered your question with regard to contingencies, and that's really what that issue was about. So if you have another question, the time to ask it would be now.
Okay, you're not going to let me have my right to ask her a question that was very relevant to her previous conduct, so.
Your
I'm gonna just ask
questions,
her to
your
recuse
questions are
herself.
premised with argumentative, incompetent facts in many ways, but you can make those arguments at the conclusion when you are making your argument as to what competent, substantial, and relevant evidence you do put forward. So if you have one more question for Ms. Collins, now would be the time.
Ms. Collins, may you please step down from the case? I understand you are a real estate agent, but your advice to me that I should have had a contingent agreement, which would be based on West Haskett's fraud, since I've proven that the lot subdivision would have happened if other than the lot width amendment that he hid from me. So it's all based on fraud. If the lot width amendment was not hidden from me, I would have had the lot subdivision. So my contingency would have been based on fraud. So I'm just going to ask you that, can you please step down from this meeting?
Mr. Mina, your time is up. You are not answering or asking Ms. Collins a relevant question, so we are going to stop at this point, and I will ask the board, based on what relevant material and substantial evidence may have been elicited during the examination, the chair would entertain a motion to either recuse Ms. Collins or not recuse.
I'll make a motion not to recuse.
Thank you, Tony.
I will second.
Thank you, Charlie. We have a motion and a second. Any discussion before we vote? None seen. All in favor of Tony's motion with Charlie's second, not to recuse Ms. Collins, raise your hand and say aye.
Aye.
4-0. Ms. Collins did not vote. Okay, moving on. Mr. McLennan is not with us today. The first alternate is Mr. Charlie Reese. Thus, the motion to recuse Mr. McLennan is moot and not relevant to this proceeding.
Mr. Chairman, do you admit into evidence all of Mr. Mina's motions and their supporting documents totaling 553 pages, which are 212 pages in the motions and 341 pages in applications with exhibits?
Yes.
Thank you.
Okay, moving on. Mr. Mina, you have filed a motion to ban any attorney in the firm of Hornthal, Ellis, Riley, and Malin from representing the town, and a separate motion to ban Mr. Willis from representing the Board of Adjustments.
That would be Ms. Wamble.
I'm sorry. Yeah.
No, you're right.
Yeah. Oh, she is in the firm. As to the question of the town's council, it is the town's choice as to what firm and what attorneys it engages. This board has neither the statutory nor ordinance authority to overrule the town on this question. Accordingly, the chair would entertain a motion to deny motion, as this board lacks jurisdiction on such an issue. Is there a motion?
For clarification, is this a motion just for Bass Horthol and not
Yes.
Mr. Wheelis?
Not Mr. Wheelis.
Okay.
Right.
Yeah, I'll make a motion. We don't have the authority, actually.
Correct.
So I make a motion that,
To deny.
To deny Mr. Mina's motion.
okay. I'll make a motion to deny Mr. Mina's motion to ban Horthol, Ellis, and Bass attorneys.
Hornthal, Riley, Ellis, and Malin.
Is that what it is?
Excuse me,
Yes.
may I get a minute to argue my position?
We can't, let's get a second. If there's going to be a second, let's get a second.
I make a second. I'll second that motion to deny the request to.
We have a motion and a second to deny Mr. Mina's motion to ban any attorney in the firm of Hornthal, Ellis, Riley, and Malin. Charlie Reese seconds. Is there any discussion?
Excuse me, do I get to, may I please argue, may I make a statement, please?
Didn't hear that.
May I please make a statement before you take your vote?
I'm sorry, sir. I'm having a hard time hearing you. Could you speak up one more time, please?
Ma'am, please make a statement before you make your vote.
Statement before he votes.
May I please make a statement before you make your vote?
On the question of
A
jurisdiction.
brief statement.
On the question of jurisdiction.
Yes, I understand your position that you're claiming to lack jurisdiction to ban attorneys from the hearing. And I just wanted to say I disagree. And I believe you do have authority to ban attorneys from the hearing based on their misconduct, which violates law. They are not permitted to misrepresent town code and get paid by Southern Shores taxpayers to misrepresent town code. That violates embezzlement laws. So you have the authority to pick up your cell phones right now and call the police on Ms. Womble for misrepresenting town code as she's being paid by Southern Shores taxpayers, because that's not what tax money is for. That's called embezzlement.
Okay, thank you.
Vote.
All right, we've got a motion and a second on the floor. We've had comment from Mr. Mina. Any discussion from the board?
No discussion.
All in favor of that motion to deny, say aye.
Aye.
Opposed, none?
Now, Mr. Chairman, that was 5 ayes.
Correct. Okay, moving on to ban Mr. Wheelis. As to the question of Mr. Wheelis representing this board, based on Mr. Mina's allegations in the motion, is there any board member that wishes to make a motion to disengage Mr. Wheelis? None seen. Accordingly, the chair would entertain a motion to deny the motion as the board lacks jurisdiction on such issues.
I'll make a motion to deny the motion, and we do lack jurisdiction over that issue.
I will second that motion. Thank you, Tony.
May I please make a statement?
Yes, you may. Keep it brief, please.
Yes, my statement is that Mr. Wheelis fraudulently misrepresented town code at the variance hearing, would not allow me to discuss my federal lawsuit, said it would be in my appeal packet. Yet I filed my appeal in Southern Shores, the planning board, and the Board of Adjustments is refusing to provide the Dare County Superior Court my appeal. So my argument is Mr. Wheelis is in contempt of Dare County Superior Court, and he lacks standing as an attorney to be sitting on the board right now hearing this case.
Thank you,
I
Mr.
understand you're
Mina.
saying you don't have jurisdiction, but there's misconduct that's clear as day, sitting right on the board there. How am I supposed to have an unbiased hearing when he's not even providing my appeal from the last hearing to the Dare County Superior Court? You haven't followed the procedure from the last case and you're in contempt of court.
Okay, thank you, Mr. Mina.
Chairman Moore, just to clarify for the record, Mr. Wheelis is not representing the town in regards to the appeal that Mr. Mina is referring to. I am, and Hornthal, Riley, Ellis, and Malin. And so just wanted to clarify that for the board and for the record that Mr. Wheelis is not involved in that appeal.
Right. Thank you, Ms. Womble, for that clarification. Okay. The motion to sanction the town and Mr. Haskett.
I think you knew.
Oh, I'm sorry. Did we vote on it?
Haven't voted.
We haven't voted. My bad. Okay, we've had a motion and a second. Motion from Tony. I seconded his motion. We've had a statement from Mr. Mina. Any discussion with the board on this motion from Mr. Wheelis? None seen. All in favor of denying that motion, say aye.
Aye. Aye.
Opposed, none. 5-0. The next motion we will look or review would be to prohibit spending on this hearing. Mr. Mina, you filed a motion
Yes, sir.
to prohibit Mr. Haskett, by implication the town, from spending town funds on council, law enforcement costs, and court reporter expenses associated with this hearing. This board has neither the statutory nor ordinance authority to order such a prohibition. The town council is your appropriate audience. Accordingly, the chair would entertain a motion to deny the motion as this board lacks jurisdiction on such issues. Could I get a motion to deny on that?
I would make a motion to deny this motion on jurisdictional grounds.
Thank you, Charlie. Second.
I'll second it.
Tony, seconds.
May I please make a statement before you take your vote?
Yes.
I think something that you really need to take into consideration is Ms. Womble's statements that she made, that she questions the town's decision to let Mr. Mina file a request for a variance for the last hearing, which was published in the Southern Shores Beacon and used to make me look like a waste of town money for the 5.5-hour variance hearing. When the reason the variance hearing was filed was because Wes Haskett instructed me to file for a variance to ask for leniency. And Wes Haskett also a second time instructed me to file for a variance to ask for an exception to zoning code. So I wanted to make sure that you were aware that I was being publicly ridiculed at the last hearing and also in the Southern Shores Beacon for filing the variance and costing the town money when in fact Wes Haskett is the reason that the variance was filed. So I just wanted to make sure before you voted that you were aware of that. What I'm trying to do is keep everybody informed that cause of this waste of money is actually Wes Haskett, not me. And then the cause of more waste of money is Ms. Womble lying and saying that I shouldn't have filed the variance hearing when her own client told me to file for the variance hearing.
Okay,
So
thank you, Mr.
You made me
Mina.
look like a waste of money. So I'm trying to save you some money right here. I think you should vote to make Wes Haskett pay for everything.
Okay, thank you for your statement, Mr. Mina.
Chair Ward, if I could just clarify for the record, I did not give any statements or make any statements to the Beacon. Just wanted to note that if there was anything in the Beacon, it would have been, I guess, from their watching of the hearing, but I did not participate in any public comment or give a statement on behalf of the town to the Beacon.
Okay, so noted, Ms. Wong. Thank you. Okay, we have a motion and a second on the floor to deny Mr. Mina's motion as this board lacks jurisdiction on such issue. Any discussion before we vote? All in favor of denying on jurisdiction, say aye.
Aye.
Opposed, none. Okay. Now on to sanction the town and Mr. Haskett. Mr. Mina, you filed a motion to sanction the town and Mr. Haskett based on allegations of embezzlement, various acts of misconduct, violations of federal law, and for failing to comply with the December 18, 2024 ruling of the Superior Court. The Superior Court and U.S. federal courts have jurisdiction over your various allegations. Nevertheless, this board has neither the statutory nor ordinance authority to order such or impose such sanctions. Accordingly, the chair would entertain a motion to deny the motion as this board lacks jurisdiction on such an issue. I'll make that
May I make a
motion.
statement?
Is there a second?
I second.
I'll second it. Okay,
Thank you, Jan.
May I make a
Okay, we have
statement, sir?
motion and a second. Mr. Mina, you may make a brief comment.
Thank you, sir. I understand your position that you were claiming you lack jurisdiction. However, it references Wes Haskett's violation of U.S. Code Title 18, 1512, C 1 and 2, which pertain to refusing to provide the court a complete verified copy of the variance hearing. So as you sit there, Wes Haskett is in violation of federal tampering with a witness crimes. So as much as you say you lack jurisdiction, the way I see it is you're sitting within walking distance of the police station and you can go get a police officer to come in there and arrest Wes Haskett for federal crimes or
Okay, thank you for your comment, Mr. Mina. Okay, we have a motion and a second on the floor. Mr. Mina has given us a brief comment. Any discussion before we vote?
No.
Okay, all in favor of my motion that to deny this board lacks jurisdiction on such an issue, please say aye.
Aye.
Opposed? Unseen? Okay. Moving on. Mr. Mina, you have filed a motion to preclude today's hearing, in effect to abandon or to dismiss it, and in turn to approve the January 6, 2025 subdivision application. You have the floor. We ask that you confine your argument to 10 minutes, please. And at the end of your argument, we will give the town the equivalent amount of time to review. So you have 10 minutes, Mr. Mina. We are going to start the clock on you when you start talking.
Sir, I apologize. I understand you want to limit my argument to 10 minutes. My motion itself appears to be about 12 pages. I can't read 12 pages in 10 minutes. And going through the motion is part of what I paid $350 for. So I understand you'd like me to do this in 10 minutes, but how am I supposed to go through a 10-page motion?
Mr. Mina, this is Mr. Wheelis. The beauty of admitting your entire package is that all of this is now evidence upon which you can argue. You don't need to go back and try to produce evidence. It is evidence in this hearing. So there's been no objection to admitting any of these items. Everything you've got, 500 pages worth, is now before the board, and it is your turn to argue that evidence that you have placed before the board.
Okay, well, as you can see with my motion to preclude the hearing and approve the lot subdivision based on the relevant, competent, and substantial evidence of the $75,000 criminal conspiracy involving West Haskett is founded on Town Code Section 36-414B not being complied with, meaning West Haskett does not have a legal reason to consider 75 East Dogwood Trail a property affected by the lot width amendment, because a prerequisite to zoning amendments is notification of affected properties. I have produced public records of the file from 75 East Dogwood Trail, the public records for notification records, and 75 East Dogwood Trail is not an affected property of the lot width amendment that West Haskett is using to deny the lot subdivision.
Mr. Mina, I'm going to stop you real quick. I'm not going to stop you, but I'm going to take the hit on this one. We failed to get you sworn. So we want to make sure we get any witness to be sworn. So if you could just take a quick break, we're not going to count it against your time. The clerk will swear you so that anything that you do say can be considered evidence in the hearing, please. I'll turn this over to the clerk, okay?
Mr. Mina?
Yes, sir. Yes,
Do you
ma'am.
swear or affirm that the evidence that you shall give this board in this action shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, Mr. Mina. Please go ahead.
Yes, my motion to preclude and grant the lot subdivision is very much founded on Town Code Section 36414B not being used at 75 East Dogwood Trail. Zoning amendments require the affected properties to be notified with posted notice prior to the zoning amendment. The public records indicate that 75 East Dogwood Trail was not an affected property. So West Haskett does not have jurisdiction or standing to use a zoning amendment that was not notified at 75 East Dogwood Trail as an affected property. And then another, there's a lot of fraud referenced in my preclusion, including West Haskett hiding the zoning amendment from me in 4 emails from May of 2023, when I was specifically asking about lot width amendments, lot width requirements, and the subdivision at 75 East Dogwood Trail. When West Haskett was hiding this, the lot width amendment was using to prevent the lot subdivision from me. The previous owner of my property negotiated an additional $75,000 from me for a lot that was subdividable, as I've proven with the subdivision plan that West Haskett denied, with one reason being his lot width amendment that he was hiding from me. So, as you sit here and have to consider taking your vote, whether there's fraud that precludes the entire hearing and requires the subdivision to be entered and approved, what you need to produce is proof of notification to 75 East Dogwood Trail in order to substantiate a vote of there not being any fraud. Because without proof of notification, you have fraud. There's about 10 other pages I could go through where it shows Lauren Womble and references specific times that she's on camera at the variance hearing fraudulently misrepresenting Town Code 36414B, and then to pretend that zoning notification requirements were met when in fact they weren't. And then after I caught her lying about the zoning code, she then tried saying that the zoning code wasn't an issue at the variance hearing. So, as I said before, that she's caught in there. It doesn't matter if the crime happened before the hearing or when it happened, it's fraud. And you can't use something that is illegal to further a conspiracy and to make additional decisions on. You can't put the fraud behind you and say, oh, it happened, we're accepting it, because I'm not accepting it. I paid $75,000 more because of West Haskett's fraud. So when you take your vote, please keep in mind that a vote to say fraud is not precluding the hearing means you have proof of notification to 75 East Dogwood Trail of the proposed lot width amendment, because I filed public records requests for proof of notification. I got a copy of the file of 75 East Dogwood Trail, and there was no notification records pursuant Town Code 36414B. So everybody that is sitting there is all sitting there because West Haskett's lies that he properly notified 75 East Dogwood Trail. And his lies are also published in the staff report for the variance hearing, saying he notified that he complied with notification records. He did not. I have an fraud insurance claim going on right now, investigating this. They may be watching it right now, for all I know, but they need to know where the notification is for 75 East Dogwood Trail being affected by a lot width amendment that West Haskett filed for on March 31st, 2023, because West Haskett lies and says it happened, but public records prove it did not happen. So when you take your vote, and if you vote against and vote for not precluding the hearing and approving my lot subdivision, please make sure you vote and present your proof of notification records for 75 East Dogwood Trail being notified pursuant to Town Code 36-414B, because that's what it comes down to. It's that simple. Thank you very much.
Thank you, Mr. Mina. At this point, I will ask Ms. Womble, do you have any cross-examination questions?
For
I don't-
Mr. Meany.
For Mr. Mina.
I don't have any cross-examination questions for Mr. Mina, although I do have some counter argument.
Well, you have an equal amount of time, 10
Let's
minutes.
go ahead and ask if there are any
Okay.
questions from the board.
Do any board members have questions at this point?
No.
No. Anybody? Okay. Ms. Wample, you have the floor for an equal amount of time, up to 10 minutes.
Thank you. I'll be brief, and I'll just want to note, there has been no fraud, there's no conspiracy, there's no embezzlement, no one has broken the law here. What we have is an unhappy property owner with the decision of town staff and with the status of the law in the town of Southern Shores. That falls far shy of fraud or embezzlement or any of the other allegations that Mr. Mina has made against the town and its staff. I just will note that the zoning ordinance is what it is. The contested text amendments that Mr. Mina continues to refer to are in fact the law in the town of Southern Shores. Were not appealed, were not challenged, they were passed. They are the adopted and enforceable law in the town of Southern Shores. If Mr. Haskett did not follow the law in the town of Southern Shores, then maybe we would have an issue. But we are here because Mr. Haskett is in fact following the law in Southern Shores and enforcing the town code of ordinances. So I ask that you would deny Mr. Mina's motion to preclude the proceedings today.
Thank you, Ms. Wample.
Can I please make a rebuttal?
No, you've had your statement, your summary there.
May I please ask Ms. Wamble where the notification records are for 75 East Dogwood Trail
No, we are
pursuant to
moving
Town
on
Code
from.
36414B?
Not this one. Variance?
May I please
So-
ask Ms. Wamble where
The
notification records are pursuant to 36-414B?
Stand by real
Chair-
quick.
Chair Ward, I will respond to you in regards to any further inquiry, although I will note that it's probably worth noting for the record further that we had a very lengthy several-hour hearing in October 21st of 2024 regarding many of the same things that Mr. Mina is alleging here today in regards to the notice, the posted notice, the advertised notice, and the proper notice, the procedure to be followed in 36-414 in regards to those text amendments. The town's position is that all the proper notice was followed pursuant to 36-414. Again, those text amendments were adopted, were not challenged, were not appealed, and are the law in the town of Southern Shores. The proceedings here today are not related to the validity of those text amendments. We are here in regards to staff's decision to deny the subdivision application.
Okay, thank you, Ms. Wamble. Okay, moving on.
You need a vote. The motion.
Excuse me, sir. Excuse me, sir.
Mr.
Excuse
Mina,
me, sir.
would you like to butt in, or, I mean, what are we doing here? We're moving on to,
We need a motion to either allow or deny the motion to preclude.
right. This would conclude your preliminary motions.
We need a motion from someone here to address that motion. That's next. We need a motion on that.
Okay. Oh, I've already read that.
You read it, but we need a motion on it.
Just that.
Yeah, because we're here now.
Okay.
So we're right here. We need a motion to either approve or to deny or.
Wouldn't that be-
Yeah, I'd like to make a motion to deny. Okay.
Hold on for a second.
Where we are is having allowed Mr. Mina up to his 10 minutes, which he didn't use all. We appreciate that.
I've been trying to say something, sir.
Hold
You
on.
hear me?
Miss-
I'm not done.
Mr. Willis is
Hold on.
sorting through.
We're
A
unwinding some
technicality,
things
yeah.
here. So at present, My recollection of my notes do not indicate that we have had a motion, one way or the other, as to Mr. Mina's motion to preclude. That is the appropriate thing now. You need a motion and a second, up or down. Then you can enter into discussion regarding that motion. And if you wish to allow Mr. Mina to make a statement as you've done on the past motions, you can do that.
Okay. Mr. Mina, you have filed a motion to preclude
Okay.
in today's
Yes,
hearing.
can I please say
And-
something, sir?
We are in the
I haven't
process
got to
of
say
trying to
something after Ms.
vote
Womble
on
made her
your motion
statements.
to
I only need a
preclude.
minute.
Sir,
I only need a minute to say something in regards to what Ms. Womble said.
you got 1 minute.
Yes, I would just like to say that Town Code 36414B requires posted notice at the property. They have not provided posted notice at the property or proof of it. They have said posted notice did not occur. And what is also not occurring is them complying with Dare County Superior Court providing a complete copy of the variance hearing. So their conspiracy is now in Dare County Superior Court. So not only did they lie through the variance hearing, they're also interfering with proceedings in Dare County Superior Court, trying to hide their lies from the last hearing. So the lies and conspiracy is just getting worse and worse and worse. And every vote you take trying to make Southern Shores look like they complied with law when West Haskett did not comply with law is just making matters worse. I mean, you just got to get to the point where accept you didn't do things right and make them right. Because the more things go on, the more lies you tell, the more problems you're going to have. It's not going to disappear. It's
Thank
You
you,
got to
Mr. Mina.
accept what it is. You don't
your-
have proof of
your minute is up.
notification
Thank you.
records, so you committed fraud.
Thank you, sir.
Thank you.
Okay,
Okay, I will entertain a motion to deny Mr. Mina's motion to preclude.
well, either deny or affirm. I'm making a motion to deny Mr. Mina's application to preclude the March 19th hearing, APA 2501.
Thank you, Tony. Is there a second? A second. Mr. Lawler seconds. Any discussion? Anybody? All in favor of Tony's motion to deny Mr. Mina's motion to preclude, raise their hand and say aye. Aye. Any opposed? None seen. Okay. This concludes Mr. Mina's preliminary motions, except for his objection to the town's motion to dismiss and amended motion to dismiss, which he will be allowed to argue momentarily. This board has read and reviewed Mr. Mina's 20-page objection that will be admitted into evidence. Ms. Womble, you have the floor.
Thank
We will
you.
ask you to confine your argument to 10 minutes or less, please.
Yes, sir. Thank you very much. I do intend in my argument to ask Mr. Haskett to give some brief testimony to the board. So I would ask that we start by having him sworn.
Okay.
Mr. Mina, can you hear?
Yes, sir.
Thank you.
Mr. Haskett, do you swear or affirm that the evidence you shall give this board in this action shall be the truth, the whole truth, and nothing but the truth?
Thank you. And Chair Ward, for the record, the town did file a motion to dismiss and an amended motion to dismiss. I will be arguing the amended motion to dismiss. They are in fact the same. There were two singular words that were left out of the initial motion to dismiss. So the substantive content of the amended motion to dismiss is the same. I just wanted to clarify for the record that for purposes of this argument, we are going to be referring to the amended motion to dismiss.
The amended is a replacement
Correct.
of the former. Thank you.
I'll just start with Mr. Haskett. Can you please state your name and your position with the town?
We're going to have him go to the lectern so everybody can have a microphone.
Okay.
Thank you.
Can you please state your name and your position with the town?
Wes Haskett, Deputy Town Manager, Planning Director.
Okay. And did you have the opportunity to review the contents of the amended motion to dismiss that was filed?
I did.
Okay. And in regards to the timeline of Mr. Mina's initial subdivision applications in July of 2024 and your denial on July 16, 2024, those dates and details are set forth in that motion?
Correct.
Okay. And in regards to the current application from January of 2025, did you also review Mr. Mina's application regarding that request for subdivision?
Yes, I reviewed his January request for the subdivision.
Okay. And in regards to the plats that were submitted with the January 2025 subdivision request, have you previously, prior to January 2025, seen those plats?
So in July 2024, Mr. Mina submitted 2 subdivision requests for the property, same
Okay.
property.
Same property. And in regards to your review of the January 2025 application, was Mr. Mina's July 2024 requests for subdivision and January 2025 requests the same subdivision request?
The request for the January 2025 subdivision was one plat, which was similar, almost exactly similar to one of the plats that was submitted in July 2024.
Okay, and when you say similar or exactly similar, did you identify any difference between the plat that was submitted in January 2025 and the plat that was submitted in July of 2024?
The only difference that I saw on the plat submitted for January 2025 from one of the plats submitted in July 2024 was the word septic area was missing on the plat submitted January 2025.
Okay. And in regards to the word septic area, is there anything about the wording or the location of the wording septic area on one plat or the other plat that impacts the requested subdivision regarding setbacks or lot size or frontage to a public road?
It does not.
Okay. All right, those would just be my questions for Mr. Haskett, and then I'm ready to proceed with my argument at your discretion.
Oh, he's up there. Can we cut you and return back?
Yes, sir.
While Mr. Haskett's up at the podium, I would ask that Mr. Mina be available to cross-examine Mr. Haskett about what Ms. Womble has just gone over with him. So, Mr. Mina, you have a few minutes to cross Mr. Haskett.
Limited to the facts that Ms. Womble,
What was that?
limiting to what Ms. Womble just asked Mr. Haskett, is that what you're saying?
That is true. The rules of evidence, it's not a wide open cross. You're limited to things that were elicited on direct examination.
I do not have any questions pertaining to those questions, to what they just discussed.
Okay, thank you, Mr. Mina. Ms. Womble, you may continue.
Thank you.
Should we know that?
It's on the record. If you want to say.
I know that the board's already reviewed all the preliminary motions, and so in summary, I just wanted to point out, and I wanted Mr. Haskett to just under oath confirm to the board again that the application, the plat, that is the substance of a request for a subdivision. So the record on this request is over 500 pages long. Although I think it's very important for to point out to the board that the key points in a request for a subdivision are all controlled by the ordinance. All these allegations, unfounded, allegations of fraud, embezzlement, and all these other allegations of Mr. Mina have no impact on a request for a subdivision, nor do they have any impact on the staff's decision to enforce a town ordinance and to review the subdivision application and make a decision to either grant it or deny it. Upon review of the amended motion to dismiss, you will note that Mr. Mina, and on July 3rd, 2024, Mr. Mina submitted 2 applications to subdivide the subject property, 75 East Dogwood Trail. On July 16, 2024, the town denied both applications. And the town denied the first application because the proposed lots did not satisfy the standards established by Town Code 30-96F, which requires both lots to front a public road. The town denied the second application because the proposed lots did not equal or exceed the standards of Town Code Section 3097, which requires lot widths of 100 feet in the RS1 Single Family Residential Zoning District. Mr. Mina did not appeal the town's denials of his subdivision applications. This is important because the town's motion to dismiss is based on 2 grounds. One, that Mr. Mina's request is outside the statute of limitations, and 2, res judicata. On January 6, 2025, Mr. Mina submitted a 3rd subdivision application, which was identical to the first and second subdivision applications and violated Town Code Sections 3096F and 3097. On January the 21st, 2025, the town denied Mr. Mina's 3rd application on grounds of res judicata, finding that Mr. Mina's 3rd subdivision application did not present any material change such that the concerns warranting the denial of the July 3rd, 2024 applications remain unsolved. Mr. Mina has appealed the town's denial of his 3rd subdivision application, stating that res judicata does not prohibit approval of the January 6th subdivision. And again, I want to note the town has moved to dismiss based on statute of limitations and res judicata. What we have here is Mr. Mina's attempt to have a second bite at the apple, even though his statute of limitation has expired. 160D 405D grants a property owner 30 days from the receipt of written notice of determination within which to file an appeal of an administrative decision. In this case, on July 16, 2024, staff rendered a written decision that the subdivision applications were going to be denied. They were not appealed. That is the standing decision in the town at this time, and Mr. Mina has waived his right to appeal those decisions. The doctrine of res judicata applies to protect litigants from the burden of relitigating previously decided matters and promotes judicial economy by preventing needless litigation. The Court of Appeals in Mount Eula Historical Preservation Society versus Rowan County went through a detailed analysis, and I cited this case in my motion, but the court went through a detailed analysis regarding res judicata and the application to land use decisions, quasi-judicial decisions specifically. And the court determined that the definition that would be utilized as a measure to determine if res judicata applies or not was whether a material change which precludes the use of the defense of res judicata occurs when the specific facts or circumstances which led to the prior decision have changed to the extent that they vitiate the reasons which produced and supported the prior decisions, such that the application can no longer be characterized as the same claim. This case was thought through and developed based on a couple of cases in North Carolina, one in which there was an application for a gas station to be constructed that was denied. It was appealed to the Board of Adjustment. Board of Adjustment affirmed, and the Supreme Court affirmed, and then the property owner went back to staff, and staff reversed their decision. And then the opponents to the application appealed, and the court said, res judicata, you cannot go back and now reapply and reverse the decision when there's been no change in the facts. There was another case the court decided this on, wherein there was an application and a denial, and then 3 years later, another application. And the opponents again said, hey, you can't do this, it's the same application. Court said, actually, the trial court, or the board in this sense, found that there was a material change of circumstances and that the traffic impacts and the traffic patterns had changed substantially in those 3 years. And so the application and considerations were different. In the case we have at hand, it is clear on its face, and it is undisputed in all of Mr. Mina's filings, even to his no questions for Mr. Haskett today, There is no change in his from his July 2024
Objection.
application to his January
Objection.
2025.
She's putting words in my mouth. I didn't question Mr. Haskett.
She's arguing the implication of you not having any questions when the only thing Mr. Haskett testified to was the consistency of your subdivision plats that were submitted. That's what she's doing.
She's talking about my
Continue,
application.
Ms. Wamble, and wrap it up.
Yes, sir.
You're about to get to the limit of your time as well.
Yes, sir. Thank you. I will. So what I wanted to note, and you've read this very lengthy, this lengthy packet and all of the motions and attachments, and even in the Mr. Mina's opposition to the motion to dismiss, his only alleged change are his allegations of fraud, embezzlement, real estate schemes, and all of these other things which are completely baseless and have zero impact on whether the town's code is what it is and the law applies to him. And so in regards to that, I think it is undisputed based on all of the filings to this point, all of the evidence that the board has received to this point, that the application from July of 2024 and the application for January of 2025 remain the same. And there is no change in the circumstances which to vitiate, and this is important, to vitiate the concerns which led to the denial. The denial was based on failure to comply with the town code. Mr. Mina has not applied or given any evidence or testimony, or even in his application that says he now complies with town code. He simply says that there's fraud, there's conspiracy. There are no new facts to allege that. So I would ask that you dismiss Mr. Mina's application based on the fact that he's outside of the statute of limitations. He did not comply with the standards to appeal of 30 days. And also that res judicata prohibits him from doing that. And one other thing I'll just note, don't forget there is a substantial record and order from October 21st, 2024, which is included in your packet under the staff submissions, where the board previously adjudicated many of the facts which are related to Mr. Mina's allegations of fraud and all of those things. So I would ask that you dismiss his matter for those reasons.
Thank you, Ms. Wamble. Mr. Mina, you have an opportunity to argue against the motion to dismiss.
Yes, thank you, sir. First of all, on July 16th, when Mr. Haskett denied the lot subdivision, he did not reduce property taxes. I went on and contacted Southern Shores about property tax reductions for taking the property right to subdivide, and they did not report anything to Dare County. I waited to January 6th, the tax filing, the tax due date, and Southern Shores or West Haskett has refused to reduce taxes for taking a property right that substantially reduces property value. So one issue, that material fact that's completely different from July 16th, 2024 is they want to take a property right, say 75 East Dogwood Trail is not a subdividable lot anymore, but they want the property taxed at a rate that it is subdividable. They've taken more than $100,000, more like between $200,000 and $365,000 worth of value, potential sales money from 75 East Dogwood Trail by claiming they've taken the property right, but they won't reduce taxes. So they can't have it both ways. It's either you reduce taxes or you're going to be guilty of tax fraud, and what they are is guilty of tax fraud. So that's one issue, since they won't reduce property taxes after they claim they've taken a property right. Which my application for a lot subdivision clearly states is based on new evidence from West Haskett dated October 14th, 2024, October 21st, 2024, October 30th, 2024, and November 19th, 2024. Proving notification requirements needed prior to zoning amendments being effectuated on 75 East Dogwood Trail were not complied with, as West Haskett claims to believe. My application says this clear as day on the first page. West Haskett went as far as lying about a May 15th planning board hearing, which heard his March 31st, 2023 lot width amendment. He responded to a public records request and claimed that there was no hearing on the lot width amendment that required posted notice. So he lied again. Lies keep piling up. When the truth is that town minutes state that there was a hearing that required posted notice, and West Haskett also sent me an email on June 1st, 2023, stating that there was a hearing at the May 15th planning board on his lot width amendment. So West Haskett's lies have continued, and whether he claims that have met notification requirements like he did on October 14th, 2024 in his staff report to the planning board, he claimed to meet the notification records. I emailed West Haskett prior to the hearing and said, please correct your false statements. I have an insurance fraud investigation going on and they need the information. And West Haskett said, I'm not changing anything on my documents. So after the hearing on October 21st, 2024, when he made sworn statement stating he complied with notification records, he then tried lying about the planning board hearing, not hearing his lot width amendment. So the new evidence that is relevant to my January 2025 application is I'm being charged taxes on a subdividable lot. And I specifically said, you need to order a tax reassessment taking property rights, and West Haskett didn't want to do it. So you want to deny my lot subdivision, you're committing tax fraud.
Mr. Mina,
Yes, sir.
I believe you are at time for your cross of, or your argument, why we should not have a motion to dismiss. I'll let you go for another minute or two, and then we're going to cut things off, and we're going to have a vote and or discussion with the board members. So if you can wrap it up along
So when
those
you wrap it
lines.
up, I'm assuming that you mean just summarize my argument? And
Yes.
to summarize my argument, I just have to refer to the first page of my application for lot subdivision, which states that tax fraud is being committed by not providing the lot subdivision, since you're taxing me for a lot that is subdividable. 2, I have all the dates of the new material facts regarding the West Haskett lies claiming that notification requirements were met for the very specific zoning code that he's trying to use to deny my lot subdivision plan. And the very last, very important fact is West Haskett lacks standing to even decide my lot subdivision plan on January 21st, 2025, because he's in contempt of the Dare County Superior Court and won't provide a complete copy of the variance hearing from October 21st, 2025. You got a complete fraud committing misconduct in the town office and trying to deny my lot subdivisions while he's in contempt of Dare County Superior Court.
Mr. Mina, thank you for that. Board, you have before you, from the town, I believe it's on page 178 in your notebook that you received. The town has put forth to us an amended motion to dismiss. Substantively, it is the same as the original motion to dismiss, but we will be voting on the amended motion to dismiss. At this point, I would entertain a motion to either allow or not allow the town's motion to dismiss. Anyone care to make a motion?
Yeah, I'll make a motion that we allow the town motion to dismiss APA-25-01.
Is there a second?
I second that motion.
Charlie, second. Discussion. Anybody?
Mr. Chairman, I think it's important to note that there's no evidence other than that the statute of limitations prohibits the appeal. Number two, res judicata, which means the matter is fully adjudicated, applies to local zoning decisions. And there's really been no evidence that the January 2025 plat is at all different than the two plats that were submitted in 2024, in July of 2024.
Thank you, Jay. Okay, we've got a motion and a second on the floor. No discussion, clarification from Jay. All in favor of Tony's motion, raise your hand and say aye. Aye. Opposed? None. Mr. Mina,
Yes, sir.
your appeal has been dismissed by this board. Your other remedies, if any, lie with Superior Court. At this point, we will return back to our meeting as the planning board and finish our agenda. Thank you to all.
Excuse me, sir. Excuse me, sir. May I say something?
Yes,
I just wanted to thank you for hearing my case. I completely disagree with you, your vote, and you're all in contempt of Dare County Superior Court's order requiring a complete copy of the variance hearing from October 21st, 2024. So your fraud has just added another day of criminal conspiracy counts to it. So have a good day. I wouldn't
okay, thank you,
expect-
Mr. Mina.
Thank you.
Okay, planning board now. We have a little left on the agenda, finished up new business. We are going back to public comment. Anyone wish to speak on the second public comment? We have two in the planning board. You care to?
What is the second one? Same thing?
No different than the first one, but you may have seen something that you need to speak to. You're welcome. You can talk about anything, potholes, taxes. You know. Okay. All right. Okay, moving on. Planning board member comments. Anybody?
My only comment, I will not be present at the April meeting. If there is an April meeting, I will not be present.
Thank you, Tony. Jane, anything?
No, I just want to say thank you to Wes for everything.
Charlie, anything?
I'll second the thanks to Wes for approaching this entire process with civility and conscientiousness.
Michael, anything? Ed? I'd just like to say thanks to everybody involved, including Mr. Mina. It has been a pretty tough sled, but we got through it, and we'll keep on moving. Announcements from Mr. Haskett.
Thank you, sir. The only thing I have is that the next regularly scheduled planning board meeting would be held on April 21st at 5 o'clock here in the Pitt Center. And don't have any agenda items at the moment. If something does come up between now and then, I'll be sure to email you all as usual.
Okay. Well, I want to say once again, thanks to my buddy here to my right. We've been back and forth a bit on this, trying to figure out the procedure and how to move forward. So I really appreciate your help, Jay.
Thank you, Mr. Chairman. I've enjoyed every minute of
No,
it.
you haven't.
I'm not under oath.
Okay. Well, I will make a motion to adjourn, and I'll look for a second. Anybody?
I'll second that.
Okay. All in favor, say aye. Meeting adjourned.
Thank you.
Wes, where's the snacks you promised?
Let me get to 5 o'clock time. Let me get to 5.